Welcome to the Open Justice Centre podcast with me, Delia, real conversations with people across the legal world, sharing journeys, challenges and the experiences behind their careers. Before we get into it, Sharon, will you tell the listeners a little bit about yourself and your role?
I'm Sharon Hewes-Lewington. I'm a family law caseworker in the family team at Suffolk Law Centre. The family team is quite small and we mostly focus on private children work, which means we're looking at disputes between private individuals, parents, relatives, anything like that, rather than between parents and the state, the local authority, which would be public children work. So we focus on private children work.
I'd like to talk about your journey. What drew you to studying law with Open University?
This is a really interesting first question. I had previously studied with the Open University. I'd done some master's level statistics courses and they were very good. They were well presented. The information was very understandable and yet no less technical for what it needed to cover. So for me personally, and for knowing about the OU generally, it was a really good, strong academic reputation. I think I first started doing some of my studying many years ago when degree courses were quite different. They were a lot more intensive, and I really wanted my law degree to be an academic experience, one that would challenge you, one that would make you think. And my previous experience of studying with the OU and, as I say, its reputation really drew me. And I was working when I started doing my law degree, so I needed to be able to fit my studying in, and I couldn't really afford to stop work either. So it had to fit around what I could do. So the usual positives for doing things with the OU, and it was affordable. I could manage to pay for the parts that I needed to do when I was doing them. And because I'd already got a law degree, the OU has got this really sensible scheme where you don't always have to do the first year of the degree. So I just did what were the equivalent of the second and third years of the law degree. Each of them took me 2 years. So the law degree took me 4 years to do years 2 and 3. So 2 years for each year. But it meant it was affordable for me. It was a very straightforward, easy decision to make with all those put together.
From a student perspective, I think that's one of the biggest draws for the OU, the flexibility of being able to work and combine that with your study. I'm glad you brought that up. So for those listeners who don't know, you qualified through CILEX. Can you explain what it means to qualify through that route?
I think I really just wanted to point out at the beginning that with CILEX, what I will describe in my route through is now called a legacy route, which really makes me sound old, doesn't it? CILEX have got a very much more updated route now. I think it's CILEX professional qualification. So when I tell you about my journey, it doesn't mean that somebody starting out now would necessarily follow the same path by any means. Have a look on CILEX. But CILEX offers what I think is more of a specialist legal pathway to working in law. If you were to take the traditional route, which is to do a law degree, a legal practice course, and then a training contract, you come out as a generalist. So in your training contract, you would generally do 3, sometimes 4, 6-month seats in different areas of law. And for that, you come out having some knowledge of all of those. For a CILEX route, you take much more of a specialist route through. So my route has been a specialist family route, and the courses that I have done and the work experience that I have got has been very much oriented towards my specialism, family. You still have to do the obvious ones, client care skills and research, all those sorts of things that you'd expect. But in terms of my particular knowledge and expertise, it has all been towards family matters. So I think that's a big difference. That's what I wanted through CILEX, and that's why that route worked for me. I didn't want to be a generalist. I knew what I wanted to work in. So that was a really positive step for me. The other thing I think I like about CILEX is that at each step of the way, you get some recognition for the level that you're at. So if you were to do, for example, a legal practice course and a training contract, you would be a trainee solicitor for your training contract. But for the rest of it, you haven't got a particular title. But with CILEX, you are a CILEX paralegal. Then you can be a CILEX advanced paralegal. And now I'm a CILEX fellow because of the stage that I'm at. But I like the fact that you have got some recognition of what level you are at before you reach the final point. So that studying journey has been quite long, but it has been very focused on family and pulling out the skills and the strengths and the experience and the knowledge that you need for it. And for me, that's been a real positive in terms of taking the CILEX route. I'm older. I could have paid for a legal practice course. It would have been expensive. Possibly not much difference between that and the cost of the CILEX, but you could spread CILEX out. And the likelihood of me getting a training contract at my age, given the competition for them, was pretty small. And I wouldn't have wanted it because it would have been 4 different seats, which I didn't want to do. So I think a lot of it is choosing what route is right for you. And CILEX, in terms of getting the qualification and the experience, this route was right for me.
Absolutely. And what you're really advising students is to understand where they are looking to go with their careers. And if they are quite specific on what they want to do, they can follow your lead and say, this is the area of law that I wish to work in. And that's what I want to work towards. That is actually brilliant advice, Sharon. Thank you. Could you tell us some more about the skills and experiences that were most valuable during your qualification?
This is a really good question. An ability to see the strengths and weaknesses in both sides of a situation and how to argue for the side that you are supporting. Now, that's exactly what you do in essays and obviously different types of assignments. I can remember feeling when I did them that it was almost artificial, looking at one side, looking at the other side, and then you come up with a conclusion. But in actual fact, when a client comes to see you, you need to understand both sides of a situation, so their side and the other party's side. You need to be able to pull out the strengths and weaknesses of each side's position, and you need to come to some form of conclusion about what options you're going to offer a client. Now, that really isn't dissimilar to the way that you approach an essay. So I really wanted to pull
Yes.
out how brilliant that approach is to the actual work that you do. Being organised is an obvious one because for many people studying with the OU, you're working and studying. And for me, I'm in a law centre. It's incredibly busy, incredibly. We try and help as many people as we can, but by goodness, the days are really, really busy. So organisation skills when you've got so much going on. When one writes assignments, needs to write succinctly, which I still struggle with because when you have working with a client, you need to do an initial letter of advice, and it's really no help if that's 13 pages long. It might be a complex situation, but you've got to write succinctly. And so when you have word counts for essays, they teach you how to try and get your point across succinctly and focus on the main parts, not what doesn't need to be in there. That really made a difference for me. And grammar and spelling, so important for client letters. But reading through your work, getting somebody to read it through, all the things that you do when you're preparing for an assignment, all of those are so important. And remembering who it is you're writing for, because if you're writing to court or the other person's solicitor, it needs to be quite formal. It needs to be really, you need to show where you're coming from. Whereas with a client, you want things to be very easily understandable. So I would always be explaining terms the first time I put them in a letter or an email to a client. But you obviously don't need to do that with other legal professionals. So that whole part of making sure that your writing is appropriate for the reader is really important. And I can remember from the OU that different assignments were aimed for different audiences and different levels of writing. And again, I think that is such a skill. So there were lots of things that were really important. And that's without the obvious ones. I think I did what was it called the Open Justice Unit then, which was working with a
Still
client,
ongoing.
is it? Which was, I mean, that almost goes without saying, but I didn't want to miss it out. That was a brilliant one for learning about case management systems.
What did you study with the Open Justice Centre?
I did obviously the unit, which covered everything, all sorts of skills that you need to know, and then worked with a group of people on a particular case and inquiry that we were given, which was quite complex. It had got lots of layers to it. But the good thing about that was, in truth, many people's inquiries they rarely come to you with a really neatly bounded, simple problem that you can say, yes, certainly the answer to this is this. I can give it to you in a paragraph and you're all done. They are usually multi-layered. So there were so many aspects from that open justice clinic work that again stood me in good stead for the work that I do. But there were many things throughout my time with the OU that really contributed to what I'm doing, and I don't think you always see it at the time.
Students who are thinking about doing the Open Justice Centre projects, you will notice how many of those skills you were working towards in your assessments are relevant. So thank you, Sharon. That's a brilliant advertisement for the Open Justice Centre, but also some practical skills for students to take away. And I think that leads nicely into my next question, actually. Would you say studying with the OU influenced your interest in social welfare?
I'd say it enhanced it. I had some personal experiences that led me to want to do family law, and I wanted to do it in a way that I felt would support people who were going through difficult times. I wanted to be able to put information across in a way that they could understand. And it was more that I already knew that I'd wanted to do that. What the OU gave me, I think, was much more of a focus. It refined what I wanted to do rather than pointing me in that direction in the first place.
That's really interesting. So it gave you a foundation, and now it plays out in practice with the work that you do at the Law Centre. Would you like to discuss a bit more about special guardianship orders and your role in those?
Parents have got parental responsibility for their children, mothers from birth and fathers either because they're married or in a civil partnership with mother, or because they're named on the birth certificate for the child. And parental responsibility is defined in law along the lines of all the rights and responsibilities that go with caring for a child. Sometimes, for all sorts of reasons, parents can't, and in some cases don't, choose not to look after their children. Sometimes people have mental health issues and can't do it. Sometimes people have learning difficulties and it just can't happen. And sometimes it's really sad reasons, like one parent dying and the other parent has just never really been that involved in the child's life. So somebody steps in to look after a child, and it's often a friend or a family member, most commonly. Those other people then don't have parental responsibility for a child, but they need to be able to make those day-to-day and important decisions that have got to be made for a child. There's a few ways that you can do it, but special guardianship orders are one way that gives special guardians enhanced parental responsibilities for children. It's a little bit like one step short of adoption. That's how big a step it is. Special guardianship orders tend to encourage keeping up ties with a child's birth family, whereas adoption more frequently cuts those ties. They're not 100% because there's a lot of talk now about adoptive children spending time with birth families, but as a generalization, that's how it often works. Because it's such a significant step in a child's life, the courts take special guardianships very seriously, and it is quite a long drawn out and quite a complex process to apply for them. And my work for special guardianships is to support people to make those applications. They're often at very emotional times of their life. If it's, for example, a child that has died and they're having to look after grandchildren, or if it's one of their children, for example, or a relative who's had really significant mental health issues and just can't look after them. Drug issues, we see all of it, but they all happen for real. And those people who are really emotional and who are at such a hard time of their life need to make a proper court application for a special guardianship order for the child or children that they're looking after. There's all sorts of sad ones, sort of situations. As I say, COVID really brought home quite a lot, because single parents who die of COVID, somebody's then looking after their children. So the application has to be done properly, and the proceedings are quite complex. So we will help people to make those applications. Now, there's recently been changes, and if you already have parental responsibility, so for example, if you are a parent with learning difficulties or a person with significant mental health issues, but if you have parental responsibility, you're likely to be eligible for legal aid to go through the process. But if you haven't got parental responsibility, then in order to get legal aid, you need to go through a means assessment and a merits assessment. And a means assessment means looking at your financial situation. Now, many special guardians are grandparents who have got some savings or a house that has got equity in it. And if you have got generally more than £8,000 in savings, you can't get illegal aid. And if you've got more than £3,000, you will have to pay a contribution towards it. So many of the people that we deal with who are applying to become special guardians aren't eligible for legal aid.
I guess it makes the process for them much more difficult to access. So the services you provide are essential for people who are excluded from legal aid, but who genuinely can't afford to go private either. And I wonder whether that gap is actually getting wider, because we're seeing more and more people try to navigate complex legal processes themselves, whether that's through online resources, self-help guides, or increasingly AI tools. Do you think that it's becoming harder to manage, especially with AI and self-help tools, for these parents who aren't eligible for legal aid? Are they now turning to other avenues for advice?
Yes, we are seeing a lot more people who have turned to something like ChatGPT to help them, for example, with court applications, or primarily we mostly see it with statements for court proceedings. Firstly, I think all credit to them for going out there and trying to find something to help support what they think is best for the child or the children that the application is about. But AI doesn't seem to take into account the principles that a court uses when they make decisions about children. And the two that stand out are the welfare of the child is the most important consideration. It's called the paramountcy principle. And the second one is the welfare checklist, which is a set of issues that are more detailed, that guide the court when they make their decisions. When people prepare applications or statements using AI, it tends very much to focus either on what they want, not what the child is best for the child, and what's gone wrong previously, perhaps in a past relationship or things in the past. And that isn't what the court are looking for. So whilst we can spend a fair bit of time with people going through it, it's that shift in focus that's the biggest one to bring about. And once you can explain to people how the court makes their decisions, the principles that they make them on, and you can spend maybe 10-15 minutes reframing what people have said into what's best for the child and what ties in with the welfare checklist, you can usually make a lot of use of what they've done. So it's refining and amending. It's not often whole scale saying, no, this really has missed the mark. We do see some, but not very many. So it's definitely a step in the right direction. An organisation called the Nuffield Family Justice Observatory are looking at reasons, and the suggestion for it is that people are turning to AI as a counsellor, as a therapist, and they are being pushed in the direction of saying, you've really been given a raw deal here. You could sort this out by taking it to court. And so encouraging people to make court applications when we spend so much of our time diverting people from court and encouraging them to solve their issues through mediation. But unfortunately, AI hasn't got there yet.
They need a bit more help with their algorithms on what their suggestions should be. AI still has some catching up to do. It tends to validate rather than mediate, and that's a dangerous default when someone is vulnerable. It's almost like it's steering people toward the most complicated route when sometimes the simplest conversation could resolve it. So
Absolutely.
that is affecting the outcome for the people that you represent, isn't it?
Yep, we think
Wow.
so. We do have to work quite hard. Obviously, mediation is not suitable for everything. Special guardianship orders need a court application. But other family disagreements and disputes, many of them you can just reduce the conflict by trying to resolve it through mediation. But if somebody's been on something like ChatGPT, they can be steered more towards court. And then we've got a real job. We have a lot of information to try and get across to people why mediation can be a much, much better option. And we need to work hard with that information.
That is brilliant. So, really, what you're trying to do is you're trying to close that gap for the access to justice by encouraging people to seek other means other than let's go straight to court. We have other steps we can take, such as mediation. With all of that in mind, the legal aid gaps, the AI pitfalls, the pressure on services like yours, do you feel there is a growing gap in access to justice?
Yes, I definitely think there is a growing gap because there are fewer law firms that will offer family legal aid. It just doesn't pay its way. And the landscape for charities to try to get funding to support the work that they do in terms of access to justice is also, it's getting worse. There is less money available. And you put those together, and I think it is becoming a lot harder to get access to justice, a lot harder. That phrase access to justice has got quite a lot of layers and levels, and
Mhm.
we work quite a lot with vulnerable people, so people who have got ADHD, people who have got autism, learning difficulties, people for whom English is not their first language, people who are victims of real domestic abuse but for whatever reason can't get legal aid and are just so emotionally fragile. And for all of those people, getting legal aid is harder. Whilst it's still out there, legal aid solicitors aren't paid for the time to make the applications. So if it's a complex application, they're not much minded to do it because they're not getting paid for a complex application. So we do quite a lot of work on helping people to put together the information, to take to a legal aid solicitor, to make a legal aid application. But given that there is only a finite amount of capacity that we have and that they have, the amount of people that we can help, I think, is dropping. And we know that there are fewer legal aid solicitors out there. We produce a list of legal aid solicitors in Ipswich and Suffolk, well, Suffolk and other major towns in Suffolk. And that list gets smaller every time we produce it. And last time I checked, I think there were 2 family legal aid law firms in Ipswich. And of those, possibly 1 solicitor in one of them and 2 in another. If they're at capacity, you're then looking further afield. And if you are vulnerable, ADHD, autism, any of the things I've said before, it is much easier for you to meet somebody in person than to do it on the phone or by Microsoft Teams. Yes, there are other people out there, but access, real access, becomes harder. People who are managing to work but are working in a gig economy, who need to be available at the drop of a hat for their employer, you make an appointment with them and you say, come in 3 days' time. They can well say on the day, I can't come, I've got to work today. And we need to understand that that is their life. If they say no, they have lost their job. So we've had missed appointments from people who say, oh, just drop of a hat, 10 minutes, I can't come, I've got to work. And one of my clients, I think, did that 3 times in a row because he has to work. And access to justice has got so many layers to it, not just the
Yes.
obvious ones. So,
Mm.
yes, I do believe it's getting harder, partly because there are also more people out there who are vulnerable in different ways. And being able to give them legal advice in a way that works for them is not always easy, especially for charities. We can make those allowances. But if you are a legal aid firm that needs to make legal aid pay, the likelihood of you keeping somebody who has missed 3 appointments because they had to go to work and only gave you 10 minutes notice, I don't know how well
Yes.
they can manage it. It's not a criticism of those solicitors.
No,
It's
but
just a reflection that access to justice, I do believe, is getting harder.
And it's a reality of the world that we're currently living in right now. This makes the work that you do, Sharon, at the Suffolk Law Centre so essential, because while the gap grows, people like you are on the ground trying to fill it. And for those who do manage to find you, what can they actually expect from Suffolk Law Centre in terms of support?
We do just about all sorts of inquiries, proceedings, matters to do with private children. So, child arrangement orders, special guardianship orders. We provide initial advice and assistance. We'll try very hard to deal with people early on in their inquiry so that we can, if it's appropriate, direct them towards mediation. But if not, we will assist with court applications, court proceedings, writing statements, negotiating with the other party, advising on whether it's a sensible move to come to an agreement if somebody proposes that. We also run what's called a family court help desk service that I go to generally every other week, sometimes a bit more often, at our local family magistrates court, where we will give information to people who are litigants in person. That used to be a bit of a challenge for me, but we've been doing it for some time now. I've been in my role for about 5 years, and we've been doing family court help desk for probably 2 years.
Mm.
So that's just about anything and everything that you get thrown at on the day.
Would you like to explain a bit more why you found it a bit challenging?
Usually, the way that you would work with clients is we would receive an inquiry form, and either me or one of my colleagues would phone a client and get some more details about their inquiry and their situation, at which point you've got a fair idea of what the matter is about.
Mhm.
In contrast, when you go to family court help desk, you have no idea who's going to be there. And so you get absolutely all sorts, some really strange, odd situations, people who have had the strangest of advice, grandparents and parents who have been advised to make applications together, where we've had to say the court's likely to tell you to separate them. Literally anything and everything that comes through the door, the strangest of things, the most upset of people. Many people think that the first hearing is going to be the final hearing, and those long-lasting decisions are going to be made on the day. And they are petrified, they're stressed, they're tearful, they don't know what's going to happen. Now I've been doing it for some time, you appreciate the central points that you focus on each time. And there are still some that I don't actually know the detailed answers to. But that really doesn't matter because I don't need to. I'm giving information, not advice. Information's the same, how the court's laid out, how you speak to the magistrates, how you can get their attention if you need to say something, the principles that the court makes decisions on. Those are all information that you can share with people. And so now I feel much more able to focus on supporting people to feel less stressed when they go into the courtroom. And that means that they can provide the court with the best information to make the best decisions for their children. So it's that switch in focus. Firstly, I'm out of my depth, it's all about me. Two, it's not about me at all. It's about how you can help people to feel that they can do their best for their children at the court hearing that they've got coming up.
So what you're essentially saying is you're providing clarity, you're providing that information rather than advice on a particular case. You're giving the client information on how to proceed in their case better. That's yeah.
Absolutely. So if people come along and they've got a particular course of action that they want to take, I can have a look at how the court would arrive at a decision, the principles that will guide the court when they reach decisions about children, and encourage somebody to look through their reasons and focus on ones that are ones the court has to take into account, not she was horrible to me last time I picked the children up. She was just so mean. Sorry, that just won't cut it. You need to have a good relationship together. What can the court do to help in your situation? So it's helping them to focus on what the court can help with rather than other aspects of their relationship, which are in truth not legal matters.
Okay, that was brilliant. Thank you. It sounds like a lot of what you do in that moment is almost translating, taking what someone feels and turning it into what the court needs to hear. And it's that kind of nuanced experience, judgment that I think makes what happened next in your career all the more significant because not everyone appreciates how much skill that actually takes. I'd like to now move on to discussing the Mazur case. So, can you briefly explain the significance of the Mazur case?
For quite some time, there had been an understanding that a range of people could do what's called litigation work. Litigation is really anything to do with court proceedings. It might be a generalisation, but I hope you just give me a little bit of slack for it just to make this easier. Mazur was a case which, when it was first decided, said that only appropriately qualified people could handle litigation matters. So all the organisations that had been set up where one person, for example, a solicitor, would have a very good overview of what was going on, but day-to-day handling of clients' cases, including litigation matters, was handled by other experienced people, CILEX fellows. I was an advanced paralegal at the time, trainee solicitors. That had gone on for some time and had been working very well. Mazur changed the landscape for that and said that only appropriate qualified people could conduct litigation. And that really came through to solicitors and CILEX people who had got litigation rights. So it made a massive difference to the work that I could do. I found it really undermining. It really knocked my confidence. But it also made a huge difference to the family team supervisor, who is a solicitor, because she had to take on so much more work. And this was a pattern that was replicated across many organisations. If you didn't abide by it, you risked criminal proceedings once the Mazur case was first decided, because that was the way the law stood. So we had to change our working practices. And I think the biggest impact of it was on clients, because we suddenly had so much less capacity, time to deal with clients, given that my work had to be completely overseen by somebody else when it was litigation work. The appeal changed that and said that providing that there are appropriate supervision methods in place and that they are documented, but people who were experienced with litigation, who did know how to do it, who had been doing it well, properly for all those years, could go back to doing it, providing those changes were put in place. Now, I know a lot of people, I have heard, a number of people, particularly CILEX people, lost their jobs as a result of Mazur. The colleagues that I work with at Suffolk Law Centre were absolutely amazing and provided all the support that I could have asked for, the opportunities to talk about how it felt and the knock-on impacts. I couldn't have asked for more, but I am very lucky. Not everybody was that fortunate. Now we've got the Court of Appeal judgment through, and we know that people, CILEX fellows, paralegals who are appropriately supervised can go back to doing that litigation work. I think we're almost in a better position, because you will now have better practices documented and in place than were there before. So those regular supervision meetings, discussions of strategies and tactics, those all happened with the family team supervisor for me. The process may not have been documented, and so not everybody may have been as fortunate as me. So I wouldn't have wished this, but I think we've got to look for the good that has come out of it.
And that's a brilliant take on that. Going on from that, despite the challenges of the Missouri case actually implemented, what essentially is keeping you motivated to continue working in this area of law?
Partly the knowledge for clients of how increasingly difficult it is to get the help that they so desperately need, especially the vulnerable clients that I've mentioned before. For me, it's almost, I don't want to say an academic challenge, but to be able to keep up with the changes in family law, because they do happen quite often, and to look at how you can try and get the best outcome for a client with the child is continually challenging. No two cases are ever the same. So for me, the stimulation doesn't go away. It is there all the time for each new inquiry that comes along. And obviously the end result, the cards and thank you letters that I get from both parents and special guardians and children, and it's just those little points at the end that just make you just have a smile and just have a nice quiet cup of tea and say, I'm so pleased for them and the way it's worked out. All of those together make it worthwhile for me every day to go in and do what I do. I love my job.
It sounds very fulfilling, Sharon, what you do. So thank you. Before we wrap up, I have a final question. What gives you hope for the future of access to justice in the UK? And what changes do you feel need to be made for that to be a reality?
What gives me hope for the future? There are dedicated people out there who care and that make such a difference. They give me hope, and they are there so often when you really, really, really need them. People will pull out the stops when it really matters. And that is absolutely lovely to see. We've asked for help in all sorts of desperate situations where it's a commercial firm and you think they're not going to help. And they do. They do. There's people and they hear and they listen and they are good people. What needs to change? More funding for absolute certainty. Obviously, generally for access to justice. But given where I'm coming from, my big plug that I say every single time, I've said I work with special guardianship order applications. To make that application costs £263. Suffolk Law Centre sometimes has some money and we will help people whenever we can with that cost. But if you're in a desperately sad situation and you're doing your best for children that you never expected to look after, to have to pay £263 for the privilege of looking after those children, when you are saving social services thousands and thousands and thousands because those children don't go into foster care, I think is just shocking. So my one big call out would be special guardianship order applications need to have a fee removed entirely. So that's a general point and an incredibly
Yes.
specific one.
And that is a brilliant note to end things on. Thank you for joining me on today's podcast, Sharon. It's been a really rich conversation.
Thank you so much for having me.